All right, everyone. Good morning or good afternoon. My name is Jennifer Ellis. I'm chair of the Solo and Small Firm section of the Pennsylvania Bar Association. It is my pleasure to welcome you to Business Interruption Insurance. Apparently, I cannot speak today. I'm very pleased to introduce to you our faculty. I'll introduce Scott Cooper, and he will introduce everybody else. Mr. Cooper is partner at the Harrisburg-based personal injury firm of Schmidt Kramer, where he focuses on personal injury law with an emphasis on motor vehicle accident and insurance cases. He's well known across Pennsylvania. He's handled quite a few important cases, and I am very pleased that he has gathered this impressive team together for you to hear from today. Mr. Cooper, please go ahead.
Thanks, Jennifer. Thanks, everyone. So just to introduce who's going to be speaking today, it's myself. We also have from Jack Goodrich, his firm in Pittsburgh, Lauren Nichols. She's been working on the cases with us and has been integral. We recently filed a motion for coordination, which I'm sure we'll talk about. And also from Jim Haggerty's firm, Suzanne Ty, who has also been working on the cases, and also our class action expert and who's been helping with the federal issues, John Shub, who recently opened up his own law firm. So congratulations in right outside Philadelphia. So he'll be having content now with this video and audio today. So, and again, if anyone has any questions, we're going to take them as we go. This way, since it seems like from doing the seminar a few other times, it's easier to do the questions as we go and then cover the issue. So as far as the business interruption, just by way of background, when this whole thing started back at the beginning of February or March, the insurance companies the economy was booming, the companies had tons of money, and in 2018, they combined had all made at least $60 billion in profits. And then they ended up having, going into this year, about $819 billion of surplus. So they were sitting on a lot of money. And in fact, as an example we give, when this started, one of the first, a lot of auto companies started doing this when people were not driving. They started giving back premiums to policyholders since people weren't driving their cars. One of the first companies to do that was State Farm, and that was $2 billion it turned out to be. And they had no problem doing that. So you could see that the insurance companies, before this started, were sitting on a lot of money. So our contention is, despite what they would say, they do have the money to pay these claims when we're successful in court. There's a lot of different issues on the policies, and generally what you want to look for, it's going to be a business owner policy, not the workman's compensation or liability. There's going to be basically for the property. And there's different issues we're going to be talking about. For the purposes of today, we're going to be focusing on the business interruption and the civil authority. And we'll go more into this, but basically the business interruption coverage is the coverage that a insured, being the company, pays for when they're down, like when they don't have 100% access to the property to be able to use it. And we'll get into the different definitions and stuff, but it basically is from the day that it starts until the day they're fully back up and running. So that's the business interruption part. There's also a civil authority claim, which we'll talk a little bit about also, and that's where the business isn't necessarily, a business could run and you could get to it and you have access to it, but because of civil authority, which in these cases are the Secretary of Pennsylvania Department of Health, the governor's order, And actually, if you're in Pittsburgh as of 5 p.m. today, the Allegheny County Department of Health, if you're forced to shut part of your premises or part of your business, that could start up a whole separate claim for, it's similar to business interruption, but it's more limited in time and scope. The business interruption generally would go until you get back up running 100%. The civil authority is going to be limited to generally either 4 weeks or 6 weeks, and we'll talk a little bit about that as well. Event cancellation is another claim that's been brought in a lot of these cases, and that's generally if you're representing like a bar that has, say, weddings or receptions, or even if you run a lobbying firm or which does fundraising. If you have a fundraising component, there may have been a lot of fundraisers that were canceled that you would make money off of because you get a percentage. All those are potential event cancellation, and that's a whole different type of coverage. Travel insurance is just a separate entity, and that's that alliance that generally everyone buys when they travel on Delta or something. It's an extra $10. Many people have bought those claims, and those are being denied under a whole separate issue. Workman's compensation and liability, that's just if you have a separate policy for that. Directors and officers, there's certain claims that are being pursued against corporations where the people are alleging that the board of directors knew about what was going to happen, and then the stock tanked for one reason or the other. Now, a lot of the stocks have popped back up, but those could be potential cases. And errors and omissions, the main ones we've seen is against insurance agents, because a lot of companies, there's actually one company in Philadelphia area that had been shopping for insurance, and they specifically asked their agent, will I be covered for business interruption if I get shut down? And this was in January, and there was an email from the agent to the client, to the customer, saying, yes, I checked with the company, you will be covered. Now when the company denied it, now they're suing both the company and the agent. So potentially for not being advised or not warning the insured, that's one of the potential claims that you could be looking at. As far as business interruption issues, there's a lot of different issues that have been going on. You mainly want to look at commercial property policy. Again, it's business owners, also the property owners. Potentially, if you own a parking lot, or if you were renting to certain people and now they're out of business, you may have a claim for that. It's going to be if you were an essential business, but also if you were a non-essential business, either or. So essential businesses may have been impacted. The reason is because you may have had supply chain issues that even if you could stay open, your suppliers couldn't stay open, and therefore your business was impacted. And farmers, in the central part of the state, there's a lot of farmer agri policies. Those are also certain cases that are being pursued. So those are areas you do want to look for. The types of businesses, the most common we've seen are restaurants, bars, gyms, dental offices, daycares, again, farmers, body shops, car dealers, the spa and hair salons. Those have all been types of businesses that you could look for. And I guess as of today, again, you start up with the bars again. The main two issues you're going to be looking at in every policy is generally the policy says we will provide you with coverage if you sustain a physical loss of or damage to your property. Everyone knows what damage to the property means. The dispute and the crux of a lot of these cases that are going to end up being litigated is what the result or definition of physical loss is. And the insurance companies are saying, well, it's physical loss. You have to, the building has to blow away, like in Wizard of Oz, Dorothy, in the house and everything. We're contending that it's physical loss of use of the premises as to what you're able to do and what it's for. And that's the everyday. And so it's as long as it's a reasonable explanation under contract interpretation, the insured should win. And all of the policies have generally the same language. It either says physical loss of, or physical loss, and then it says or damage. And Lauren will talk a little bit or Suzanne will talk a little bit about the arguments that are being made. To show you how common this is, the NAIC, which basically is the insurance company's organization, did a data call, and of all the companies, mainly in America, throughout the United States, except for 3 states, to see how wide this language was and different things with the exclusions and stuff. The physical loss of language is in at least 98% of the policies. So basically almost every policy has it. My thinking would be that it's probably in every policy, but you can never guarantee 100%, so they just put 98%. And then we'll talk a little bit about some companies have a virus exclusion that we think we're going to be able to argue why it doesn't apply. But in the same data call, they estimated that 83% of the policies have the virus exclusion. So you could see the breadth of at least the physical loss. It's basically almost every policy. The civil authority are, again, the government orders or Secretary of Health or Department of Health in Allegheny County. That is what is shutting down the businesses or access to the businesses. As far as types of cases, there's different cases you can bring. There's the declaratory judgment. That's mainly what we've been pursuing in order to try to keep as many cases in state court. There's a declaratory judgment with a class action component. You could also do a breach of contract. The bad faith issue, I think at this point, I'll ask Suzanne what her opinion is on it as well. I think right now it would be hard to argue bad faith for them denying the coverage because it's an unsettled issue. It would be more that if companies start losing the cases and then the companies don't at least try to negotiate or offer, I think it would be too premature to argue bad faith for not paying these claims. And Suzanne did a lot of this before she started with Jim doing the plaintiff side. Would you generally tend to agree on that?
Yeah, I agree. I think on the bad faith claims now, I think they're going to rely on the older case of Terlitsky, which held that where it's unsettled law, there's not really a case for bad faith. Now, an interesting aspect, and I know you talked about it a little bit, is the exclusions. And, there are some arguments to be made about how the exclusions were inserted into the policy, and that may be an area to explore. But generally, I agree with you. Right now, the focus would be on the declaratory judgment.
Yeah, and one of the issues that we'll probably talk about is the exclusion is back in 2000. The virus exclusion was added in 2006 from the Insurance Services Organization, and one of the representations made was that the exclusion would not be restricting people's coverage, and it would only apply if there was actually viruses on the property themselves. And there's an argument that's being raised in a lot of these cases about regulatory estoppel, that if it was misrepresented to the insurance commissioners what the reason for the exclusion is, then the exclusion just falls all by itself. So the insured's position, Suzanne's going to discuss that. And also, could you just briefly mention about ISO and what that is when you're covering it?
Sure. Just hopping in on the exclusion issue. Another, as Scott pointed out, a lot of these policies were amended in like the 2006, 2007 time period, which, number one, sitting here in 2020 seems like a long time ago, but it really isn't in the life of policy. And there's case law out of the Pennsylvania Supreme Court, it's Baumhammers, which indicates that when an existing policy is modified, the insurer has to provide notice, in appropriate typeface of those changes. So this may be if you've got a claim and they're denying it and they're saying it's because of this 06 change, and you've had a policy for 20 or 30 years, you're a restaurant, you've had it for 10, 15 years or whatever, ask for the notice that went out when that policy was changed, because that may be a quick way to really call into question the whether or not the endorsement was properly added, whether you were given notice. Scott talked a little bit about ISO. That's the Insurance Services Office, and their main offices are located in New York, and they work for insurance companies and they provide standardized forms. So if you're looking at an insurance form and you look all the way down in the bottom of the left-hand corner, you'll see it'll say like ISO and then a form number, like ISO 2500. And those are standard forms. And some smaller companies that are not as large and maybe don't practice in numerous states, they may be writing their own policies, and they're called non-standard policies. And those typically are a little stranger, and they may provide some ground for you to challenge. They may not have the exclusion, or they may have a more poorly worded exclusion. So you'll definitely want to look at whether your policy is a standard policy or an ISO policy or a non-standard policy. As Scott talked about, these are primarily in the business owners policies, and you'll want to look in the coverage section, and it'll be listed as business interruption or business expense. And it will also, if you're a restaurant, it may have additional coverage for spoliation and loss of product and that sort of thing. The main issue, what's at issue here, is that the business was closed, or the business was limited in its ability to have customers there, to serve customers outside as it normally would, to conduct business as it normally would. And so you're going to look at the insuring agreement, and the insuring agreement is going to define what's the basis for the claim. And these are breach of contract claims, essentially. So you want to look at the insuring agreement. The insuring agreement is going to say that they'll pay for physical loss or physical damage to the property. That phrase is not defined in the policy. And as Scott said, insurers are hopping right on and trying to say, well, that means you have to have actual physical loss to the property. On the insured side, on the business owner side, we're saying that physical loss is the loss of the use of that property. And there are a number of cases, especially there's one case in the Third Circuit, and I know that, Scott, you probably have the case name at the ready. It's flown from my mind, where they've held that the presence of bacteria, of E. coli, in a facility, and the release of, I believe it's ammonia in a facility, constituted a physical loss or physical damage. So that's the real rub. And from the plaintiff's perspective, from the claimant's perspective, you've purchased this insurance for your business to ensure ongoing business as it was before. You've had an event that has restricted your use of the business to use it as you did before, and that's the basis for the claim. The other claim is there's coverage for civil authority. If, again, your loss, your use of the building, of the premises is restricted because of a government order that restricts your access or your use of the building, we're maintaining that is the basis for a claim. And again, what it comes down to, again, this is why you bought the coverage. The reasonable expectation was that there would be coverage for an unexpected interruption in your business through no fault of your own. And of course, no one had any notice of the scope and extent of this loss. So I think that's worth taking a look at. So you want to get from the plaintiff's perspective, you want to get the policy. You want to take a look at the policy. You want to look at whether or not you have the endorsement. You may want to challenge the endorsement, and also just generally that the loss of the physical damage, the physical loss is not defined in the policy. The insurers are, as we'll talk about down the road, taking a very straightforward, they're trying to really use case law developed in handling claims arising out of hurricanes, where you have to have a tangible loss to the property to result in coverage. And here we're saying, no, the policy is broad enough to provide coverage for a loss of use.
I have a question for you. And it's, are you seeking referrals with these issues to you guys? And if so, I assume these are contingency matters and referral fees may be paid.
Yes, we're doing all the cases on contingency fee, 30% contingency fee. We don't charge for the costs unless we recover, and then the referral fees are 25% out of our recovery. And the case that Suzanne was talking about, if you're looking at, there's a New Jersey case. It's Wakefern, WAKEFERN Food Corporation versus Liberty Mutual Fire and Insurance. That's the most local case that talks about that physical loss does not mean physical alteration of the property. And there's also a case out of Michigan from the early 1970s, the Supreme Court, and that actually probably applies even more, that there was riots and the city shut down all these businesses and restricted the business use, and the Supreme Court of Michigan said that would also be a physical loss of use of the property. Any other questions?
Not at the moment. Thank you.
Okay. So as far as cases that have been filed so far, and there's a few more, and I'll ask Lauren just to talk in a minute about the Tambellini, what we're doing there. Is Tambellini versus Erie Insurance is the first case that had been really filed, and it's the lowest Erie insurance number in the state. That we initially sought to get King's Bench on, just to have the issue determined on the physical loss. The one thing about all the Erie policies, it does not have any exclusion. So if you're looking at an Erie case, that's a non-ISO case, and there is no exclusion. So the main issue is really going to be the physical loss of language. The HTR case is another case that's filed in Allegheny County. It's a class action, and that we're trying to do some stuff with Tambellini, which we'll talk about. Winburn Medical is a hospital facility out in Johnstown, and there's a class action filed there. Right now, there's a motion for judgment on the pleadings that's been filed, but that won't be a decision for that in a little bit. Dianoia Eatery was in Allegheny. And the reason I'm putting this on here is because Dianoia Eatery versus Motorists was in declaratory judgment action that was filed in Allegheny County. And one of the things we've been doing is filing declaratory judgment only actions without any other remedy sought, because under Third Circuit and United States Supreme Court opinions, the federal court can decline to exercise jurisdiction even if there's diversity, if it's purely an issue of state law that's unsettled. So we're arguing that these are unsettled issues of state law, and therefore we're asking for a declaratory judgment only to have a court decide it and work its way up to the Supreme Court. In Dianoia, initially we filed in Allegheny County motorists removed it to the federal court, and the judge sua sponte within 3 days sent it back saying it was a state issue and it wasn't going to be heard. Subsequently, motorists refiled and took a second bite. Now they're arguing that even though we're asking for declaratory judgment, it really sounds like a breach of contract. So now we filed another motion to remand. So that's sitting there right now. And last, and this is something that's going to be, you'll probably read a little bit more about it in the next month or so, because there's a hearing coming up on it, is what's known as multi-district litigation. And John Shub's going to talk about that in a minute, is where a series of cases are filed in federal court in different parts of the country. And what some lawyers are doing is trying to have all the cases put in a multi-district litigation. And John, can you talk a little bit about that, and also how it may or may not impact the state court cases?
Sorry about that, Scott. Sure. So, as you folks probably know, there's a system in place in federal court to try to deal with situations where there's tons of cases, and it would not make sense at times. Perhaps this is one. We'll discuss that in a moment. For there to be all these different cases around the country in different district courts coordinating doing separate discovery. They do this when there's a big mass tort case. They've done it in opioids. They did it in the NFL concussion cases. It just doesn't make sense to have more than one judge trying to coordinate discovery in certain instances. And it's called the multi-district litigation panel, who decides these issues. And they meet 3 or 4 times a year. And litigants petition the court, the multi-district panel, to decide 2 things. The first is the threshold issue. Should the litigation be consolidated or coordinated in one venue? That's the first issue. And that's a very dicey question at times. And in this case especially, that's the threshold issue I think is going to be the most important one here. Should it be a multi-district litigation? And the court, the panel usually considers a few factors. Will coordination make sense in a case where, like here, there are literally dozens and dozens of different insurance companies with dozens and dozens of different policies? In a mass tort case, it's typically much different. Obviously, it's one type of illness or a couple types of illnesses with one defendant, basically one theory or a couple theories of liability, and conducting unified coordinated discovery makes a lot of sense because you're going to use the same discovery in all the cases. Here, on the other hand, we don't have that situation. We have a lot of different defendants, and even certain defendants have different policies in different states. And this is not at all going to be a federal issue in any way. It's all going to be driven by state insurance policy. So there's a major battle brewing in the federal court as to whether or not these cases should be coordinated, sent to one district court, and number 2, if they should, where should it go? There are lots of plaintiffs' firms that are asking for coordination. There are lots that aren't. There are a lot of defendants that are arguing that there should not be any coordination because there's just too many disparate fact situations here. And the second, again, battle, if the court does decide, the MDL panel does decide to send it, the question where. There are 2 major courts that seem to be at play right now. One is the Eastern District of Pennsylvania, and the second is the Northern District of Illinois. And there's players that are weighing in on both of those jurisdictions to the extent they want coordination at all. So first issue is, should there be coordination? Second issue is, where should it be? My view here is that the panel is not going to coordinate these cases in the federal courts, because I think there are just too many different cases with too many disparate policies and fact patterns that would not lend itself to coordination. At best, they may coordinate by defendant. Maybe they'll give certain defendants to one judge, and maybe another defendant to another judge. But certainly to throw them all at one judge, I think makes very little sense in this case. And so it's going to be an interesting battle. The hearing is in a couple weeks, and they usually take about 3 weeks to decide the issue. So lots of people will be watching closely to see how it all plays out.
Thanks, John. And John, so basically, because it's all the different companies with different policy languages, that's probably the biggest hurdle. But if this was, say, one company only, there would probably be a better chance of them doing the MDL, just hypothetically.
Yes, I agree. As long as there were numerous cases. They won't do it for 2 or 3 cases. But if there were 10 cases, against State Farm, and that was really the only defendant that was at issue, I think there's a pretty good chance you would see multi-district litigation coordinated somewhere, since that probably makes sense, even if the state policies are somewhat different.
Gotcha.
So,
which leads me to going back to Tambellini. Our thinking is in Tambellini, what we've done, and Lauren will explain this, is we're actually now trying to coordinate the Erie cases. So Lauren, can you just give an update on that?
Yeah, absolutely. What a wonderful little segue there. So in Pennsylvania, we actually have our own sort of mini MDL statute or rule of civil procedure under PA Rule of Civil Procedure 213. You can coordinate cases that have common issues of facts in a designated court within Pennsylvania that you will file a petition to have it coordinated there, which is what we chose to do in the Tambellini and HTR matters. Within the past week, we filed a motion to coordinate in Allegheny County and are seeking to have those cases heard with the complex and commerce litigation court here in Allegheny County. Because common issues of legal fact do predominate here. It's one insurance company with substantially similar, if not absolutely identical policies. Certainly in Tambellini and HTR, that's the case. And we have consent to coordinate here in Allegheny County from attorneys handling cases in Lancaster and in Philadelphia as well. Also against Erie Insurance Exchange with the same issues as in Tambellini and in HTR. We think that coordination would keep from having unreasonable delay or expenses and give us the best opportunity to move these cases forward in the most expeditious manner. So that's what we're seeking to do. We don't know what the insurance company's position is on that yet. Nobody has told us, so we're waiting to hear, and we have a status conference with the Commerce and Complex judge on those cases at the end of July.
Thanks. And then one of the issues we've also seen, especially with a lot of the Pennsylvania insureds, is what happens. The insurance companies generally, or the agents, are telling people you don't have a case, you didn't have damage to the property, therefore you do not need to open a case, and we're not going to. So how do you force this, or what should you do, Lauren, if we're gonna, because it's important, and maybe explain about the notice issue?
Yeah, absolutely. So the first thing to do, if you have a client or somebody who you worked with before, or anybody who comes to you and says, I'm interested in this, I've sustained a loss to my business as a result of either the pandemic generally or the orders from the government, the first thing they have to do is make a claim with their insurance company, and they can open that claim by either calling an agent or any insurance representative. Usually the agent might be somebody who they have a relationship with, so we're recommending that that's where people start with these. A lot of our clients, though, have been told in that initial phone call with their agent that their potential claim isn't covered. No use even making a claim. They're not going to pay anything. Don't even do it. I don't know. We don't know this right now, but it certainly seems like that was, if not an industry-wide, in certain cases, at least a company-wide directive that, hey, we're just not going to cover these things, and you might as well tell people initially. Don't let the person or the business stop there. Make them tell their insurance company that they want to open the claim anyway. And when they're doing that, when they're trying to open the claim with the agent, they need to make sure that they have a full copy of their policy. If your client can't find that policy, they need to ask for the agent to send it to them. But it's really the best if they can find the policy that was issued to them when they first opened the policy. We have particular issues with State Farm on this, and if they're State Farm insured, they seem to only want to send these sample form policies out, and they'll be stamped with sample on them. So really try to get your client to find that policy, and if they can't, ask the agent for it. The policy is what's actually going to dictate why they have the, why they think they're denying the claim, or why they think they have the ability to deny the claim. Not every policy is the same, so you have to have that in order to proceed with the case. Make sure you tell your clients to cooperate with any investigation the insurance company might do, and keep notes on it. It's highly unlikely they're going to do any investigation. We're seeing claims where somebody, reported their claim to the insurance company on, say, March 27th, and they get a denial letter in the mail on April 3rd. Obviously 6 days, not enough time to visit the location, do any kind of really full or robust investigation. So make a note of the specific date that you submitted your claim. And if the claim is denied, you want to make sure that that is done in writing. If there's a verbal denial, you want to note the date and time and who you spoke with, but press them to send that denial in writing because that's a big part of the case. It's the only way you're going to know what the real basis is for why they're denying the claim. You want to make them tell you why you don't have coverage for this. Some companies we've seen are issuing straight denial letters. Others are issuing reservation of rights letters. Functionally, at this point, those are the same thing. No payments are being made. Down the line, it might be important to just keep have an understanding of what the document is that's being issued. And with the reservation of rights letter, if you have further losses and you want to submit more information to the insurance company, you can certainly do that. Though I don't think it's going to change their mind. I will also say that continuing to operate in some way is not a bar to recovery in a business interruption case. So, obviously there are lots of bars and restaurants out there that have been able to continue doing takeout, or now in Allegheny County, restaurants that have a bar component can still operate. They just can't sell alcohol on their premises. But that ability to do business in some limited way is not a bar to being able to make the claim. And in fact, there's case law out there that says that business interruption claim with some continuing business is fine, because otherwise there would be no motivation for the insured to try to mitigate their damages. If and when your claim is denied, we talk a little bit about the insurance commission and whether they could do anything. In some of our cases, we're trying to make a consumer protection argument, but often those laws only apply to individuals and not to companies. So it's not something that we're pursuing particularly aggressively at this point. Though the bottom line is that there's not going to be anything that anybody can do to get you this coverage without a fight, which is why we have all these suits filed. Our group is working with insurance experts as well as an infectious disease doctor and a bad faith expert. As we talked about already, we don't have any bad faith claims filed yet, but we're ready to make the argument when the time comes. And I wanted to just add one last thing to something that Suzanne said earlier about the insureds not having any expectation or any understanding this is something that could happen. This is no fault of their own, totally out of the blue. I think that that is certainly something that we can say for the insureds. I don't think we can say the same thing for insurance companies. This might be something that I missed in the PowerPoints that I might be stealing somebody's thunder here, but we have PowerPoints all the way back from insurance industry seminars to 2015, where they talk about the potential issue of a pandemic and what the arguments would be against providing coverage for their insureds even back to then. So.
Yeah, and Lauren makes a good point also, because a lot of the companies are saying that this was never anticipated or anything. And one of the problems that especially Erie runs into, because if they didn't think that this would ever apply, why do other companies have a virus exclusion? Why do you need an exclusion if you can't anticipate having to provide coverage? And as Lauren pointed out, we do have the PowerPoints going back to 2015 and 16 where they were showing there's going to be, you should consider pandemics and insurance coverage. And in fact, ISO, which was what Suzanne was talking about a little bit ago, going back to February, actually had an advisory to policyholders that basically explained to them, and it says advisory to insureds dealing with coronavirus. You may or may not have coverage for business interruption, and you should check your policy and look. So why would they need to send this to people? And the companies never sent it, but they created it. So it does become an issue that you can argue from either side. And because there's no definitions and these policies are not clearly worded, the important thing to keep in mind is, as long as there's two reasonable interpretations, the insured prevails. The insurer is the one that wrote the contract. So if they wanted to be more clear, they can, and they probably should be doing it for the next pandemic, but not this one, because they're going to lose.
Scott, is there
Yep.
any danger in filing a claim? In other words, can the company refuse to insure you at some point, or is that part of bad faith?
Suzanne, do you want to take that and then cover their exclusion, the positions?
Sure. You know, the big issue is that if you make a claim, you know, will your premiums go up? And, you know, premiums are, policy premiums are calculated on past payments. So, and it's an overall pool of payments. So what's going to end up happening is, if these claims are made and paid, then everyone's premiums are going to go up, regardless of whether or not you made a claim and you participated in a claim. You know, I don't think that they would be able to cancel you for making a business interruption claim under your policy. But that is a concern, because, you know, you're a business, your business has been negatively impacted. Now you're going to try to make a claim, and you want to see some negative consequences. There should not be any negative consequences made for just making the claim. And again, any premium increase would be down the road based on payments paid out to the pool of individuals making claims. So even if you're not making a claim, you're likely going to pay some increased premiums down the road, should they choose to increase premiums based on this kind of coverage. I don't know if anyone had anything to add to that.
No, that's what I've been telling people. And,
but a legitimate concern.
yeah, and you know, so that's as far as whether they could cancel you. But now, once you bring the claim, these are generally what they're arguing. And Suzanne, do you want to cover that?
Yeah, I mean, so again, you know, the defense position, the insurer's position is going to be right back into the policy language, and they're really going to hone in on, you know, the two phrases we're all sick of hearing at this point, you know, property loss and property damage. And again, those terms are not defined in the policy, and despite the insurers writing the policy and not defining it, they are uniformly taking a blanket approach that means tangible physical loss to property. And that is really in the absence of, you know, the case law that Lauren and Scott addressed a little bit about how other courts have considered the impact of the presence of E. coli, the presence of ammonia, I think it was, on a structure, resulting in a physical loss to the structure. Nonetheless, the insurance company has just taken the stance that those exclusions are to be interpreted as written. And they're just saying, if there isn't, you know, physical loss, if there's not tangible physical loss, there's no coverage. They're also arguing that, you know, that your property, your access to the property hasn't been restricted or limited due to, again, and falling back to no physical loss, no physical damage. Also, they're taking an argument. I've seen the denial letters that are coming across, some are more broad, and some are really trying to take on this argument that also there wasn't a government shutdown order that was a result of a physical loss to your property or within a certain geographical area. It's sort of akin to, again, the hurricane, the flood example. So they're trying to say because there wasn't a localized outbreak, because your property wasn't, the virus wasn't present there and there wasn't physical loss, that it's not restricted. One of the interesting issues that's come up is, what if you're an ongoing business and you have an employee who tests positive and you have to shut down for a few days for for cleaning purposes? Is that enough to satisfy the government order? And I think that's still that's still open. That's still being argued. And then again, the virus exclusion. Some policies have it, some policies don't. You'll want to look at it. One of the things I want to talk about a little bit about was Scott and Lauren talked about how you're getting denial letters, you're getting a reservation of rights letters. You want to scrutinize those, especially the reservation of rights letters, because the insurers are getting a little overly broad, and you'll see that they're starting to throw around physical loss and physical damage and interspersing some other terms. And if there's a ground for ambiguity, you may want to explore that. But from the insurer's perspective, it's pretty much an open and shut case at this point. The claim is made, the claim is denied. Like Lauren said, they're not doing any investigation. And as Lauren said, from the insured's, the claimant's perspective, we should nonetheless be taking steps to categorize and amass the damages, the loss. But right now, the insurers I don't know of any insurer who's paying the claim.
And as far as the force majeure, one of the things people think you can argue an act of God, but one of the things I think the companies realize is, because they anticipated this, going back, as Lauren said, as early as 2015, potential claims, it makes it real hard to argue that it's an act of God. Going back to the reservation of rights, one of the cases you may want to be aware of is a couple months ago, the Superior Court decided a case, Selective Way Insurance versus MAK Services. And that dealt with a slip and fall case dealing with snow and ice removal. And the insurance company had initially issued a denial letter, a reservation of rights letter, and they never included a certain defense. And then eventually the case was litigated, and 18 months later, then they asserted a different, an additional reason why there was no coverage. The Superior Court said that the reservation of rights the denial later on was insufficient because it wasn't in the reservation of rights initially. So you want to look, if there's a reservation of rights, why it's being denied, because an argument can be made that they can't bring up something new. So if they deny it based on physical loss of, that there's no physical loss, and they say the pollution exclusion, I don't think, using this Superior Court case, at least you have an argument that if they find out they had a virus exclusion a year later, they can't come back. They were stopped from raising that because they should have done it earlier on. Does anyone have a different take on that?
Question. If a client thinks they have a claim, should we refer them to you immediately or try to place the claim and refer after the denial letter?
What we've been telling people is just refer them to us immediately, and we've been talking them through and explaining to them what to do to file the claim, get the denial, but at least get us the policy up front so we could start looking at it and find out which company it is and things like that.
Thank you.
And then we're almost done. Some people have asked about legislation, and then we may have a couple minutes for more questions. There's two pieces of legislation that basically are the same, Senate Bill 1114 and Senate Bill 2372. And essentially what that does is give, it requires the insurance companies to cover for business interruption claims as a result of this pandemic going back to March. It's well intended. The one potential problem, and this is the reason I don't think it's really been voted on and going to pass, is it automatically provides retroactive coverage for an insurance, for a vested right under the insurance policy. And there's certain case law that would say it's unconstitutional to require companies to go back and pay something. The court, if they're interpreting the law as it is, that they can force the companies to do, to pay, but you can't really do the legislation. You could do it prospectively, but not retroactively. House Bill 2386 by Representative Mahaffey. This is a bill that, and I'll explain why I don't think it's going to end up being passed either, but it's out there, would basically allow companies that have business interruption cases to go to the state, and the state, being administered by, I believe it would be the Pennsylvania Insurance Department, would pay the business interruption claims for the companies, thereby not having to go through the insurance claims process. The problem with that is who would pay the claims would be the taxpayers and the state. So one, we already have a budget problem this year because of this whole shutdown. But two, you're not going to raise people's taxes to pay the business claims. My suggestion to the legislature was have the insurance companies volunteer to pay the claims and then let them go to either the state or the federal government for a bailout, as long as they agree not to raise premiums for 5 years. But I don't think any of that's happening. So if you're looking for legislation, I don't think that's going to be happening anytime soon. There was one other bill that is out for potential being introduced, and that was basically saying that insurance companies moving forward are going to be required to pay business interruption claims and civil authority claims if there's a pandemic. It's specific to pandemics. That hasn't been introduced yet. So with that, time's almost up. If anyone has any other questions, why doesn't everyone, if we'll start with John and then I'll go Lauren, Susan, if you want to give everyone your email addresses, if anyone wants to get in touch with you. And John's on mute, so let's start with Lauren.
Now he's not. He was, but I got it. It's J Shub, SHUB, at Shub Lawyers, SHUBLAWYERS.com. Thanks for your attention, everybody. It was very productive.
And my email address is Lauren, LAUREN, at Goodrich PC. That's GOODRICH PC, as in professionalcorporation.com. And again, thanks everybody for signing in today, and thanks for your attention.
And this is Suzanne. It's a S, as in my first initial, TIGE, TIGHE, at HGSKlawyers.com. And thanks, and hope everyone has a good day.
And mine is S. Cooper, like Scooper, at Schmidt Kramer, oneword.com. And with that, I want to thank everyone. Thanks, Jen, and I'll turn it back to you.
Thank you, Scott, and thank you to our speakers. Are there any other questions, anyone? I'll give you a minute to ask questions while I remind you that, of course, the Solo and Small Firm Conference is coming up. It's up on PBI's website. There's a link from PBA's website. The discount code for members of the Solo section has been sent out on the listserv as well as through other means. RPPT lawyers also qualify for that discount. We do not have any more webinars planned until right now, July 20th. So if an ad will come out for that soon, but if we plan on any more prior to that, I will certainly let you know. But of course, we're mainly focused right now on the conference for July and August. So I see no further questions, and with that, I would again like to thank our faculty for taking the time, their very valuable time, to join us today, and also for handling this important situation which is affecting law firms as well as all sorts of other businesses throughout the Commonwealth. Thank
Yeah,
you.
and also we're doing a couple cases for law firms too that had specifically set like real estate settlement closings and that they were impacted by and things like that.
All right, I'm sure a lot of law firms were, of course, since we were not deemed essential, a lot of law firms were affected as well. So with that, again, my thanks. Wish you all a great day and a great week, and I hope to see you again soon. Bye-bye.
Thanks, everyone. Stay healthy.